Welcome to all of you, and thank you for attending. My name is Gabriella Blum. I am the Rita E. Hauser Professor of Human Rights and International Humanitarian Law here at Harvard Law School. And I'm also the Faculty Director of the Program on International Law and Armed Conflict, also fondly known as PILAC. And this is a PILAC event, and I first want to thank Naz Mudirzadeh, our Executive Director, and Dustin Lewis, our Senior Researcher, for putting this wonderful event together. You should know that this event is being recorded, and it will be available on the PILAC website afterwards as a webcam event. Today's topic is the cyber operations and international humanitarian law, fault lines and vectors. So the news is rife with stories about cyber attacks, cyber espionage, cyber operations, cyber crime, and the actors range from basically anybody you can think of. So they include North Korea and China and Russia, as well as the United States itself. It also includes armed groups, corporation groups, and just individuals around the world. And yesterday there was a dinner here, not far from here on campus, honoring Secretary Madeleine Albright. And at the dinner, Secretary Albright was asked, what she thought about cyber attacks and what we can and should do about them. And the Secretary said that she was appointed to lead an expert group in NATO to think exactly about this question. And the more specific question, should cyber attacks be considered attacks for purposes of Article 5 of the NATO Charter, meaning an attack on one is an attack on all, the same article that sort of calls the coalition around the invasion of Afghanistan post 9/11. And the Secretary explained that part of the problem is merely attribution. How do we know who's behind these attacks, and can we ever make sure? And the other, related to this one, but sort of a more generic problem, is that we just don't know what the rules are. We don't have rules. We don't know what the rules are. And this is, she talked about arms control agreement in general. Just yesterday we had a first sort of broad document of understanding with Iran over nuclear weapons. Nuclear weapons are easier in the sense that there is the government's domain, there is a monopoly over them, you know who the address is, they're easier to monitor. Cyber is so much more complicated. People, individuals, all of us have access to it. We use cyber all the time, mostly for wonderful purposes like paying your bills online or downloading Netflix. And some minority margin is going to use it for very bad purposes. And as the Secretary noted, we have no rules. We don't know what to do. So with us here today to help us figure out the rules is one of my favorite people, a colleague and a friend, Professor Mike Schmitt. And Mike Schmitt is one of, I think I've said that before, right?
I don't know what's coming next, but I certainly agree with
one of the really the world's top experts on the laws of war in general. I've been teaching laws of war for many years. I've practiced laws of war before that. When I have a question, I'm not sure about it, Mike is the guy I call, and I say, what's the answer to this? And he's, so I'll tell you a little bit about his credentials, and then I'll talk about this particular context. So Mike holds numerous titles spanning multiple countries. He's the Charles H. Stockton Professor and Director of the Stockton Center for the Study of International Law at the United States Naval War College in Newport, Rhode Island. He's also a professor at Exeter University in the UK and a senior fellow at the NATO Cyber Defense Center of Excellence. We're proud to say he's also a fellow of PILAC. And with us, he received degrees from Durham University, the University of Texas, the Naval War College, Texas State University, and also has an LLM from a small school in New Haven. And in April...
Don't get me started. Don't get me started. Do you know what all Harvard LLM students have in common? A rejection letter from the LLM program at Yale.
That is so not
okay,
true
bada-bum.
and so not cool. Two things, not true and not cool. By the way, I am an example
Yes.
of someone who did their LLM here.
I know.
Instead.
I know.
Okay. We'll fight over this later.
We'll fight over this.
Bad beginning. In April 2013, Cambridge University Press published the first, if you want, black letter rule book on cyber operations, and it's called the Tallinn Manual on the International Law Applicable to Cyber Warfare, with a commentary on these rules. The Tallinn Manual is the first effort of its kind to try and capture how international humanitarian law, how the laws of war in general govern cyber operations in the 21st century battlefield. And Mike literally wrote the book. So this is not a metaphor. He really did. In today's lecture, he will discuss some of the difficulties in this field, how the Tallinn Manual attempts to address them, some of the remaining questions. How long are you going to go for? Do you know?
I think it's 1 o'clock. I need to stop by, correct?
Right. So why don't we make sure we leave some time for questions and answer. After Mike's talk, I might pose a couple of questions for him, and then we'll open it up for your questions. Please join me in a warm welcome to Mike Schmitt.
So thank you for the warm welcome, despite my initial comments about relative LLM programs. Actually, I found this interesting that the Secretary was talking about cyber and saying that there really aren't a body of rules. There's not a body of rules for cyber. I think exactly the opposite is true. And it's been my position for some time now that international law is rather robust, and international law can be applied to cyber in a way that in a way that's very logical and meaningful. I'm particularly interested in the Secretary's comments because I was just at NATO a couple of weeks ago. The Secretary General invited me to address the NAC, which is the accumulation of all the ambassadors from the various NATO countries in a closed session. And I very much had the sense that the Secretary General and the NAC really believed that there wasn't a body of law which governed robust responses to cyber attacks directed against members of the alliance. And hopefully I dissuaded that group of that, because I think international law is pretty good, although there are certain problems, certain difficulties, and we'll talk about those this afternoon. Today I'm going to talk about exclusively IHL, although cyber covers lots of other areas, sovereignty, jurisdiction, jus ad bellum, and so forth. I'll talk just about the IHL issues today. Okay, let's start at the beginning. The beginning is actually in the 1990s. In the 1990s, we began to look at the issue of cyber in war colleges around the world, most notably the War College in Newport, the Naval War College. I was then a student, an Air Force officer going through the program there, and cyber, everyone was talking about cyber. Everyone was. And so there was an initial conference there in 1998, held by the law department to look at the law of cyber warfare. A book was produced. I was the editor of the book and so forth, and everyone was embarking on cyber. That was the new thing in IHL, in the jus ad bellum. However, then 9/11 happened. And when 9/11 happened, all of us that worked in the field quit doing cyber or frankly anything else and focused on the issues that had been raised by 9/11 and the subsequent conflicts that followed, like detention, torture, you know what's going on. Until 2007, because in 2007 something very interesting happened. Estonia had acquired its independence again about the year 2000, I think it's 2001 actually. But anyways, Estonia had acquired its independence after having been occupied by the Soviet Union from the time of the Second World War. And like every capital of a republic in the Soviet Union, there was a statue in the middle of Tallinn, capital of Estonia, to the Great Patriotic War. I mean, you can close your eyes and imagine socialist realism, Great Patriotic War, fighting off the evil Germans. But to those Estonians, that was a statue not to the Great Patriotic War, but rather that was a statue to the occupation of their nation for nearly half a century. And so they wanted that statue moved because this was offensive to them. So in fact, they moved the statue. It's called the Bronze Soldier. They moved the statue to a very appropriate place, a Soviet cemetery, Soviet war cemetery, just on the outskirts of Tallinn. But this made the ethnic Russians crazy. Because to an ethnic Russian living in Estonia, and there were lots of them by this time, the population had become 23% ethnic Russian because it's a rather pleasant place. To those people, it really was the Great Patriotic War. And this was a real affront to move this statue. And so therefore, riots started in the streets. And the riots were enabled by cyber. Because online, in social media, the Russian ethnic Russians were saying, take to the streets to protest the movement of the statue. And then this happened. What happened was that all over the world, 177 countries, all over the world, Estonia started suffering cyber attacks against both their government cyber infrastructure and their private cyber infrastructure. You can see some of the examples here, ISPs, the president's office, and so forth. They weren't destructive. They were merely disruptive, but it really shut the country down for about 10 days. And this captured the world's attention. And it captured the world's attention because by now, Estonia was a member of NATO. And Estonia, Gabby had just mentioned, Estonia, a member of NATO, Article 5 of the North Atlantic Treaty says collective defense. So Estonia said, okay, we're being attacked. Can you come help us? And we said, what? You want us to fight the Russians? Well, we're in Iraq and we're kind of tied up right now. So we were able to get through this politically, but this captured everyone's attention. However, this issue wasn't really IHL. This was the jus ad bellum. However, the very next year, in 2008, we now see IHL come to the front because Georgia attacks a breakaway area in the country called South Ossetia. The story's complicated, but when Georgia, it's actually Georgian territory, when they try to take control of this territory back, the Russians are already there as peacekeepers, and an international armed conflict breaks out between Russia and Georgia. A bad one for Georgia. I mean, literally, the Russians are marching on Tbilisi, the capital. Contemporaneously with the launch of operations, literally within 2 hours of the first shot being fired, up on a Russian website comes a list of targets and malware. So if you want to attack one of these evil Georgian websites, president, a bank, you can see the address, the proper address, and you can then download malware that will enable you to attack that particular IP. And so that's what happened during this international armed conflict. Again, there were attacks against Georgia, all sorts of targets, private and government, not very severe, disruptive, not destructive, and the longest ran for 6 hours. Georgia wasn't affected nearly as much as Estonia because Georgia wasn't as wired as Estonia at this time. But still, it caught our attention. Now we're thinking about cyber again. So in 2009, NATO decides to do something about it. I'm going to talk about that in a second. But since 2008, cyber and IHL has become a huge topic because there's been cyber in virtually every single conflict, every single one. It may be as simple as getting on Facebook and using social media to organize, or they may be very robust military-type operations. In Libya, there was talk about using cyber to bring down the Libyan air defense network. There was a decision not to do that because of uncertainty over the law. But nevertheless, cyber was used for targeting purposes to identify targets. The Syrian Electronic Army, of course, remains active in the Syrian conflict. The Russians used it in Ukraine. And states are very much beginning to organize for cyber warfare. The most robust being, of course, the United States with our creation of the United States Cyber Command. And all of the services also have their separate cyber commands. But other countries are getting into the game, most notably the Dutch. The Dutch have created a cyber unit. The Brits have long cooperated with us, and a number of other countries are getting involved. NATO is very hesitant at the moment. What I was there talking to them about was something called active defense. So you have passive defense, that's firewalls and stuff. Active defense is where you kind of sort of shoot back at someone shooting at you. And I talked to them a little bit about integrating offensive cyber operations into their regular kinetic operations. So NATO's still struggling to figure out what it wants to do. NATO's nervous about this. But individually, lots of countries are developing cyber capabilities. And so the question is, what's the law? Well, what happened in 2008 after Georgia, NATO decided to create a Center of Excellence for Cyber Issues called the CCD-COE. And they came to me and asked me to put together a group to look at the law governing cyber warfare. Initially, we were only going to look at IHL, the jus in bello. We eventually grew that to include the jus ad bellum, use of force issues and self-defense, because we thought that states would like that. How did we do it? We brought 20 experts from around the world, a very politically incorrect group of experts, because we knew we were doing this for the first time, so we really didn't care if we had geographical distribution, et cetera, et cetera. We took the 20 best people we could find. The only requirement that was consistent across all 20 is the person that made it onto what we called the international group of experts had to have experience, has a practicing legal advisor. So for example, I had been an attorney for the Air Force. We had a Canadian officer. We had people who had advised ministries of foreign affairs. We had former International Committee of the Red Cross representatives, people who had done this. So if you were just purely an academic, you didn't make the cut. At any rate, we were assisted by nothing. If they're purely academics, I do respect you. Okay, we knew acutely. Gabby and I were joking before the session. She said she's written this wonderful book, which you all must know about by now, on technology and so forth. And I'm the cyber guy, but she doesn't really know how to do Skype. And I've got this ancient phone that opens up like this. So we were acutely aware of our limitations. And so what we did was we were accompanied at all times by a technical team that provided us advice. And then there were 3 advisors, one from United States Cyber Command, the senior lawyer from United States Cyber Command, to keep us honest, because we wanted to make sure we were dealing in the realm of the real, and that individual was the one that knew what was really happening. We had an International Committee of the Red Cross representative, because they basically own humanitarian law, and they're always spectacular attorneys. And then we had a representative from NATO, primarily because NATO provided us the cash for the project, and if you give us money, you get a seat at the table. So NATO was there as well. We produced the manual that I'll talk about in a second in 2013. There is an ongoing project now, a follow-on project, which I think is very interesting. It's called Tallinn 2.0. See how clever and original we are. Tallinn 2.0. And what we are doing is we're looking at cyber issues, what we call below the threshold, a term that is caught on. Below the threshold, referring to cyber operations that don't rise to the level of a use of force or an armed attack in the context of the UN Charter, okay? And an operation that doesn't rise to the level of an armed conflict. In other words, it's not occurring during an ongoing war. So the day-to-day stuff, the classic recent example, the Sony hack. So now we're looking at the law governing that. So our issues are sovereignty, jurisdiction, state responsibility, countermeasures, air law, space law, law of the sea, international telecommunications law, human rights. Good luck with that. We're rather skeptical on that one. And a number of other types of law. And we hope to finish next year. We've promised the manuscript to Cambridge University Press in early 2016, but because we want to maintain our reputations as academics, we will in fact not meet that deadline. And I anticipate, because they have to show us respect, okay? And so we anticipate we'll give the manuscript to Cambridge University Press in mid-2016 with that project. I'll be happy to talk about that. The one difference between this project and the first one is the first project, which resulted in the manual, states state arm's length, okay? Because who are these 20 people? They're making the law. Holy cow, we make law. We're really nervous about this. So officially they stayed arm's length. Behind the scenes, they desperately wanted to know what we were doing because they were in the process of writing rules of engagement. So there were many behind the scenes connections. This time, states are actively involved. In fact, in 1 week, a week and a day, I'll be in The Hague meeting with about 40 states on the progress so far in Tallinn 2.0, and then we will have a subsequent meeting later on. So states are very, very interested, and they want a voice in this process. However, the PILAC folks have invited me down to talk about IHL, which is not the subject of Tallinn 2.0. I will tell you that it was easier than we thought. We thought, oh golly, I mean, this is so new, and how are we going to do that? It wasn't so hard. Because most of IHL is adaptive. It's designed to be an adaptive body of law. It's designed for new weapons. There are rules on new weapons, for crying out loud. So what it meant was that we spent some time interpreting norms in the cyber context, But in many cases, we all went, yeah, okay, that makes sense. You can't attack medical things, and you probably can't attack medical databases. That's hardly a juridical epiphany, right? But some of the things were hard. I just thought I would talk about in these few moments the three that were most difficult for us in terms of applying IHL in the cyber context. The first is attacks. Now, the problem arises here. If you look at the additional protocol, Article 48, which is customary in nature, we believe, reflects customary law, an important point because the United States is not a party to the additional protocol. But we believe this, Article 48, is reflective of the principle of distinction, and it accurately states the principle of distinction. The problem is, has set forth in Article 48, it basically says, you got to distinguish between civilian objects, military objectives, civilians, and combatants, and direct your operations only against military objectives. So this begged the question for us, does that mean that IHL rules out any cyber operation against something that's civilian? And that didn't quite seem right. That seemed to be an overbroad notion to us. So we wanted to explore, what do they mean when they say operations? Does that really mean any time the military does something? Well, the group, we spent 3 years thinking about this, so in the next 4 minutes I will summarize it. But the group focused on the fact that although it talked about operations in Article 48, the protocol, and really our understanding of customary law, really is about attacks. The word attacks. You can't attack civilian objects. You can't attack civilians. You can't engage in indiscriminate attacks. Attacks are limited to military objectives, on and on and on and on. So our logic was, yes, we have a general principle, Article 48, general principle, no operations directed against civilians, but what they really mean is attacks. So then it begs the question, as lawyers, we have to ask what? So what's attacks mean? Okay, now we know what operations mean. What's attacks mean? Well, fortunately, the protocol, actually very unusual, has a definitional provision in Article 49, and it says what they mean by attacks. An attack is an act of violence, rather an offense or defense. Act of violence. Okay, violence. So what do we mean by violence? Well, we looked at the protocol and we said, well, violence means you break things or you hurt people. Dangers, loss of life, damage to civilian objects. With regard to the environment, be careful about widespread, long-term, and severe damage, losses. And then we looked at commentaries both by the ICRC and by a group of very famous legal scholars led by Michael Botha, a German. And they, again, are talking about violence and physical force. So what this told us is that operations means attacks. Attacks means violence. Violence means breaking, hurting. Breaking things, hurting people. It means what you think of when you think of violence. So how did we apply this in the cyber context? Well, the problem is that cyber can, but often doesn't actually break things. I mean, you're beaming obviously I don't understand the technology, but you're beaming these things and they're not violent. It's not like if I throw a rock at you, right? It's not like that. But we said IHL has already accounted for that. IHL is really not worried about acts that are violent in terms of kinetic force being transferred. IHL is worried about consequences. And we came to that conclusion by analogy to biological and chemical warfare, in which there's no kinetic release. But for decades, people have been saying, well, clearly you can't conduct biological warfare, not only because of the special law, the lex specialis on biological warfare, but just because you can't do it, because they're civilians. So if that's the case, then what we mean in IHL with regard to the restriction is you can't engage in an attack that will cause injury or death to individuals, or that will cause the damage to or destruction of physical objects. And that was our rule. So that rule up there, 30, is our definitional rule of a cyber attack. And it's important because if you engage in an operation like that, and it has those consequences, and you engage in it against a protected person or object, then it's a violation of IHL, and very likely it's a war crime. Okay, now, since you're at Harvard, you should be frustrated with this definition. And you should say to yourself, golly, that can't be the rule. It can't be the rule. And the reason it can't be the rule is because you can engage in all kinds of cyber operations during an armed conflict that can have devastating consequences for a civilian population, but that don't break things and don't injure people. That they, for example, collapse an economy would just be an example. And so we had a long, long debate about this, a debate that only started to come together in terms of arriving at a majority view in the very end, and we came up with what was called the functionality test. And I mean, I will tell you how it came up. We were panicked because this is the essence. Attack is the essence of IHL, okay? It's the center of IHL. And we thought, holy cow, we can't produce this book with all these cool rules, and we just don't address the most important thing or come up with some rule that everyone says is unsatisfactory. So the way the functionality test came, there was with non-attribution, but a very brilliant person working for a certain organization that's dedicated to humanitarian causes, and myself, and we're talking by email from different continents. We're both in a hotel late at night, ring, 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 ring. And this person said, what about focusing on functionality? And that was, it clicked for me. It made sense. So what the majority, here was not a unanimous view. The majority of the experts would say that damage includes an operation that, albeit not physically damaging or destructive, affects the functionality of the cyber infrastructure against which it is directed. Okay? Now, this was a very, very important, very, very important. However, because we were lawyers and there were some law professors, we had to argue. We came up with something elegant, but let's have an argument because that's what we do in law, okay? So, some of the members of the IGE took the position that the functionality test meant if I have to take the computer to the computer guy to repair it, like you have to replace the logic board, that's an attack that affects the functionality. Now I said, you gotta be kidding me, it's gotta be more than that, because like I'm a computer idiot. And you know, I don't really care what the computer goober does. When I go down there with my, I don't really care. I don't care if he or she gives me a logic board, which I don't even know what a logic board is, or they reload the operating system, Yosemite, whatever, I don't care. What I know is that this doesn't work and it's broken, okay? So you can hit my thing with a hammer, or you can break the logic board, or you can do something to whatever the OS is, but I don't care, it doesn't work. So there is another group within the functionality test people, I'm one of them, that says the question is, does the thing not work as intended, okay? And within this group, there are people that say, oh, but you have to, but we're talking about reloading the operating system and others. I don't buy that. My question is, does the thing work or not? And if it doesn't work, it's damaged. And if it's damaged, then it enjoys the protections that other civilian objects will enjoy. I will tell you, there is a remaining minority of the group that there's a minority that's stuck with this. Then there's the majority that took the functionality. Then within the functionality test, there's the I have to physically repair, I have to replace the operating system, or the Schmitt view, which is it just doesn't work. And then there are others that say that's the wrong test altogether. That's the wrong test altogether. It should be simply about the severity of the consequences. Because if we're talking about the economy, you may have severe effects, but you may not affect the functionality of any particular object. By the way, functionality, we're not talking about mere denial of service. It's not simply interruption. It's the thing doesn't work. It's the object doesn't work. So this is one of the areas where we see fault lines. This debate rages daily. If you want to write a paper, there's lots of material, okay? It's an easy paper to write. Pick this subject, okay? Now, it's the second big question. Another debate that is raging on. And that's this, data as an object. You've seen the rule that says you can't shoot at civilian objects, and that's true in cyberspace. This is our rule in cyberspace, okay? Rule 37. Civilian objects can't be made the object of cyber attacks. What's a cyber attack? I just told you what a cyber attack is. We don't know, okay? But at any rate, so if you have one of those things that I really don't know about, you can't direct it at a civilian object. And people then ask the question, is data, and I never get this right, but I'm at Harvard, so is data or are data? Are. I don't want to slow things down because we have limited time here with these delicate questions. But we'll use the is because I was educated in the UK for a while. So, is data an object? Because remember, if it's an object, and if it's civilian data, then attacking it would be a violation of IHL and indeed a war crime. And indeed a war crime. Now, that was our rule, and we could not come to an agreement on this. The majority, and it was a large majority in this case, the majority said data is not an object. Why did we say that? We looked at the commentary to the additional protocol, which actually talked about, the ICRC commentary, which actually talked about what the term object meant. And it says that an object is something that is visible and tangible, and I can't see data, and I can't hold it, so it's not visible or tangible, okay? Now, this is an interesting issue because we, to some extent, took this clause of the commentary out of context. I will admit that up front in case anyone's doing an SJD on this subject. We took it out of context, but we said the ordinary meaning is, in fact, visible and tangible. I mean, I'm holding Naz's phone. This is an object, okay? The brilliance that's in the halo that always surrounds Naz is not visible and tangible. It's not an object. I mean, it may be real, but it's not an object. And so we said, visible and tangible, the ICRC tells us, ordinary meaning of object is something I can hold in my hand. We don't see any state practice whatsoever suggesting that data will be protected as an object, so there's no state practice, there's no expression of opinio juris, nothing to suggest the interpretation should change, and perhaps most importantly, remember I told you that everyone had been a legal advisor. A lot of us said we do these operations all the time. This is called a PSYOP, a psychological operation. Are you telling me that I can't hack into the enemy's database and put a clown nose on their leader's face? Well, that would require me, wouldn't it, to go in and manipulate data? Are you telling me that's illegal now? That's silly. That's silly. And so the majority said, data, not an object, therefore, if you're conducting cyber operations against civilian data, that's not an attack on a civilian object. The minority said data is, and the minority of the minority said data are an object, okay? And they were focusing on the centrality of data in day-to-day life. I mean, really, so if I have my computer here, I really don't care if you break my computer. But if I lose the article I'm writing, man, I'm suicidal. I mean, I'll go nuts if that happens. But the computer, I'll just buy another computer. I'll put it on a credit card, charge it to the Harvard PILAC program, okay? And so they said, you're not paying attention to the way the world's changed. I think both sides are right, because neither the approach which says it's not data is satisfactory, nor is the one that says it is. Under-inclusive, over-inclusive. And so therefore, I think we have a real problem. IHL, as I put down here, is a body of law designed to balance military necessity and humanitarian considerations. The view of the first, the majority view, overemphasizes military necessity. The view of the bottom overemphasizes humanitarian considerations. Both views have got to be wrong. They're not acceptable. Neither of those views is acceptable. Here's my view of what I think what will happen. I think the majority view is going to prevail because states are not going to be willing to give up their ability to, for example, conduct operations against data during counterinsurgencies where you're trying to deprive the enemy of the support of the civilian population, or during general psychological operations. States simply will not accept the notion that data is an object, period. That is an object, period, because they will want to attack it, even when it doesn't qualify as a military objective. Second, So what does this mean? It means that for now, data will be protected either because of the attack interpretation I've told you, functionality. In other words, I protect the functionality of the system. You can't manipulate the data if it's going to mean the system doesn't work, the cyber infrastructure, or because of special protections. I don't have time to go into it, but there are lots of special protections in IHL. Medical data is protected as medical data, not because it's an object, but rather because it's medical data. Ditto with regard to humanitarian assistance data, protected not because it's an object, but because of the function. However, I don't think this is going to work, so I have suggested in a couple of articles that maybe what we will see happen is we will see the emergence of a new customary norm over time. And my idea is that we should not be able to conduct military operations against something that is related to what I call essential civilian functions. This is a completely undeveloped idea. It's a very transparent attempt by a scholar to try and get his gig out there. It's the Schmitt idea. But I think there are certain things that most states today would agree we shouldn't go after, like the economy of another state. An economy that would dramatically affect the civilian population, or the ability of the civilian population to communicate. I mean, because it's so essential in modern society, and on and on and on and on. I think that we'll never be able to do this by treaty. Forget it. It's not going to happen. It's too sensitive. It's too fluffy and so forth. But we may see state practice. You may very well see operations where you avoid striking data that would fall into this category. And if we can talk about it now, my idea is we can fold it into rules of engagement that will create the state practice necessary to form the basis for a new norm. But we'll see. Last topic, and then I'll stop, was what do you do about all the civilians that are engaging in cyber operations? This is our rule, Rule 29. Contrary to public belief, I don't know where it came from, there is this belief that civilians cannot engage in hostilities. That's completely wrong. That's completely wrong. It's perfectly acceptable for civilians to engage in hostilities, but what it means is that there are certain consequences. A civilian is protected from attack, but not when you're participating in hostilities. Harm to a civilian is calculated into the proportionality analysis, but not if the civilian is participating in hostilities. So it's not that civilians can't engage in cyber operations, but if they engage in cyber operations, they lose their protection from attack for such time, and that's important, as they so participate. This is drawn from provisions in Additional Protocol 1 and 2 of the Additional Protocol. Protocol 1 for international armed conflict, Protocol 2 for non-international armed conflict. This is called the rule of direct participation. If you directly participate in hostilities, you're targetable. You don't count in the proportionality analysis. And if the enemy is attacking, they don't have to consider your presence when determining how to minimize civilian casualties. I want to very quickly distinguish groups that engage in hostilities from individuals who do. If you're an organized armed group, then you're targetable just like you're in the armed forces. It means around the clock. It means there's no for such time limitation. It'd be very hard to have a cyber organized armed group, an exclusively cyber organized armed group that's like Anonymous, that because the organized armed group has to have some command structure, has to have a means of enforcing discipline. And if it's us, we're all in the group, but I don't really know who you are in real life. How am I supposed to enforce discipline? It's very difficult to do. So we won't see a lot of that. What we'll see is individuals who will participate in the hostilities exactly like they did in the Georgia case. Remember 2008? Thousands of cyber attacks against Georgia, mounted not by Russian soldiers, not by their cyber units, but rather by ethnic Russians against Georgia from all over the world. So this is a huge problem. So there are two issues here. One is, what is the activity that's problematic? And the second is, what does for such time mean? In the interest of time, there was a major study conducted by the ICRC for 5 years. I was one of the experts involved in this called it was a study into the notion of direct participation. where we struggle to articulate what qualified as direct participation such that I can attack you. Surely it's not simply expressing sympathy for the enemy doesn't mean I can attack you, but if you're shooting at me, I probably can attack you, okay? So what does it mean? At what point do you lose your immunity from attack? We came up with 3 requirements: threshold of harm, direct causation, and belligerent nexus. They all apply in the cyber context. Again, for the interest of time, let me basically tell you that the rule is, if you are engaging in cyber operations during an armed conflict, and they hurt the enemy, so you're maybe you're a civilian and I'm military, you're probing into my systems to try and find vulnerabilities such that you can then give that information to someone else. That's direct participation, and you lose your protection for attack during that time, okay? So if you're engaged in activities that help the other side or hurt me with regard to the conduct of military operations, that is direct participation. And that's hugely problematic, because when we're talking about regular kinetic warfare, we're talking about 100 people, maybe 500 people. Here, we're talking about tens of thousands of people. If you attack Estonia tomorrow, virtually everyone in Estonia, they're a very wired country, they're all going to start, if you're Russia, if your name's Putin, they're all going to start banging on you through cyberspace because they know how. So the question is, does that mean now the population is targetable? Can he just stop dropping bombs on Tallinn because the number of people? It's a good question. It's an open question. And then there's the for such time. Again, you may attack these people, but only for such time as they engage. I won't go over the debate. The big question is how do you apply that in a practical way in cyberspace? If you're only vulnerable to attack for such time as you're engaging in the hostilities, in cyberspace, by the time you identify the bad guy may have stopped. May have stopped, because it takes the time to attribute to identify. They may be online for just a moment. Does that mean I can only attack when I find you online? Or can I attack around the clock? That's not important. Many times the attack will be conducted, but the effects will not be obvious for some time. So my point here is there are 2 problems with direct participation. One is the thing that they're doing really, are you really going to make the entire population subject to attack when they rise up against you? And then the second, how does the for such time requirement fit in the cyber context? I don't know the answer to these questions. So, last slide. Vectors, directions of the body of law. You must remember that international humanitarian law is a balancing act between military necessity and humanitarian considerations. Every single rule is a reflection of this balance, trying to find the appropriate balance. That balance is shifting. Activities in cyberspace infinitely more important than they were 5 years ago, more important than they were 10 years ago, et cetera, et cetera. So the balance is shifting. Expect the law to shift into a greater protection of your activities in cyberspace, because that will be seen as a humanitarian consideration. How will that play out with regard to attacks? The functionality test, particularly my approach, will be widely accepted. The Schmitt, widely accepted, universally accepted. With regard to data, I anticipate seeing emergence of a new customary norm because it's just too hard. Both approaches are unsatisfactory. Expect to see a new norm emerge. And with regard to participation, it can't be the case that you can drop a bomb on every 17-year-old kid that's hacking into your systems and military systems. So I believe that requirement will become more demanding. But on the other hand, the notion that you have to strike while they're attacking you doesn't make sense in cyberspace, so the timing will be broadened. So you'll require a greater impact on enemy forces, but your targetability, the window of opportunity to target, will be broadened. And with that, let's take questions. We have 12 minutes.
So, first of all, thank you. This was fascinating.
You have to say that you're my host, but if a student says it, I'd really appreciate it.
Half of them are my students. I'll have to say it regardless, so it doesn't matter. You started out by saying there are ways in which cyber is different, there are ways in which cyber isn't different, but I could see that tension throughout your presentation. Right, so it seems to me that in some ways you took cyber too seriously, and in other ways you didn't take cyber seriously enough.
Okay.
In the sense that a lot of these things have analogies in the physical world.
Right.
And that was could be one way to think about it. So actually the conversation about data really surprised me because data has an obvious analogy in the real world. This folder exists in the real world or it exists on a computer. I don't know why that makes a difference or why that's important.
Yeah, it's a very good question. The answer is because you have to ask, not only is there an analogy, but what's the consequence of carrying the analogy out to its logical conclusion?
I agree with that, but once I can think about the analogy in the real world, I answer the question. So the question is, what type of data is it? And is it permissible to harm? And even your clown example doesn't make much of a difference because I can send a covert team that would draw a little clown on posters of the commanders in the military base, right? And once I can do that, there's no reason why I couldn't do it through cyberspace. Cyber actually makes no difference. It would make a difference if I had to think, for instance, about the infrastructure itself. What happens in the infrastructure itself? That brings me to the damage question. The attack question. Functionality here doesn't make any sense to me because I don't really care if the machine is broken or not. What I care about is the consequence of harm. How much harm is conducted? How much harm is inflicted? Is it long-term? Is it reversible? It was too quick to sort of say denial of service isn't counted.
Right.
And in that sense, I don't think you took cyber seriously enough. You sort of reverted to the physical world in a way that just doesn't make any sense to me. I don't care if the computer is working, if I can play solitaire on it or not. The question is, what is actually happening in the physical world or in the virtual world that is very physical today as a result?
So of course, Gabby, of course you're completely wrong. So these are absolutely wonderful questions, and with respect to both of the points you make, I happen to share your views on both points. However, you must understand what our terms of reference were. When we undertook the project, we swore on a stack of Bibles in front of 10 bishops that we would never, never, never delve into lex ferenda, that we would be strictly tied to lex lata, in other words, the law as it is, and that we would not go beyond what we believe states would be willing to accept, and we actually had a date on June 2012. So when we got to both of those issues, let's take the data as an example. Although I find it compelling, and that's why I've written about essential, because I find our answer completely unsatisfactory as a matter of lex ferenda. Completely unsatisfactory. But what we said there is we do not believe that states are at the point now where state legal advisors would say data is an object per se, such that the prohibition on attacking civilian objects would apply because the consequences are overbroad. So although intellectually I happen to...
Alexandria Library, is that not a war crime?
It is a war crime, and we addressed that. It was the Yale Law Library. We addressed that, and what we did was the protection of cultural property. So we did have special protections, but your point is a very, very good one. It's just we were very hesitant about getting out ahead of where we thought states would. And in the commentary, by the way, the manual doesn't take positions, period. What we do is we say, here's a broad position we all could accept, but there are many interpretations. And your interpretation, consequentiality, is one of the minority positions that we said. Some people said consequentiality was lex lata, not lex ferenda. So you would be in the minority. But we were careful about that. And so that was objects. And with regard to functionality, there was a group that focused on severity of consequences, but the reason it was rejected by the majority is because generally severity of consequences is not an approach taken in IHL. So although we were sensitive to that, and I believe that's where the law's going, as I said. In IHL, you generally don't think about how bad is the harm to the civilian object. You think, I've harmed a civilian object. You protect certain categories of individuals and certain categories of things. So although there was great sympathy for your view, This wasn't the normal approach taken in IHL. Yeah. But dual use, I can answer that quickly. The group almost universally agreed that dual use, an object that is dual use, is a military objective no matter how slight the use. Again, consequentiality is factored in only when we get to proportionality. Next question.
Thanks very much. It was an interesting presentation. I'm Alex.
Thank you, because that seemed very sincere. Okay.
I'm not even in Professor Blum's class. I'm a 1L here, though, and this might just be my own misunderstanding of the of some of the factors that you were going through. But I'm somewhat curious about possible tensions between the question about attack on data as not being an attack on an object, and also the functionality test that you put forward. Because obviously, if you attack the data enough of functional objects, the objects do not work as intended. So
Correct.
the obvious example being Shamoon, Sony, etc.
Right.
Likewise, if you were to compromise a computer system, presumably, and you realize that your computer was leaking all sorts of data, presumably you would take it to a tech guy and say it's not working, it's giving all my data to the Chinese instead of to my other generals. So how does that sort of fit in with that? I mean, I'm sort of curious as to how, if those two things are in tension, or if I'm just really misunderstanding this.
No, you understand it perfectly well. That is the functionality test. The functionality test was designed to answer exactly that question, an attack on data, because we were uncomfortable with the limitation of physical damage, because most cyber attacks don't involve physical damage, but the thing doesn't work anymore. And the way we got around that was by saying, although you're attacking the data, in fact what you're attacking is the object. Hence the functionality test. And so the object, the notion of object as something tangible isn't the data, it is the object. So for example, there are weapons where I can drop a bomb and it will create overblast that will, you look nice, I don't want to kill you. Sir, no offense. I drop a bomb and I use the overblast to kill the gentleman here. It's the overblast that caused, but the harm, the attack, the object of attack in IHL terms was the gentleman here. And so we said the same with regard, even though you're attacking data, the object of attack is in fact an object as understood in IHL. And so that's how we got around it. But your confused look is an appropriate look. Because exactly as I said to the professor, we were very acutely sensitive that we were trying to capture. That's why you had to have been a state legal advisor. Acutely sensitive to what we were trying to do was to capture for state legal advisors what the international community is likely to say when there is an attack. And we felt that states weren't ready to go that far. Well, I will tell you that I anticipate that in 5 years that will change. I'm writing urging it to change, because of the concerns you have. But we wanted to maintain fidelity to the law as we believe states would interpret it on that date. Because our audience was not academic, was not a law student or a professor. Our audience consisted, our intended audience were legal advisors in ministries of foreign affairs, ministries of defense, militaries, private companies that might engage in cyber operations, NGOs, practitioners. And they need to know, not theoretically does this make sense, but what's going to be the call. That I concede all of the criticism on this basis. Yes, ma'am.
I don't know how appropriate this question is.
I'm sorry, Dustin. I'm not good at this. Okay. Oh, it's our last one. So make it a long one, multi-part. Okay.
I don't know how appropriate this question is, but I was wondering whether the committee has taken into consideration the issue of distinction if the government or the military organization is engaging in a cyber attack as opposed to a civilian.
Yes.
Would the same considerations of distinction that is generally applied on
Right.
the field be applicable in this sense as well?
Absolutely. So we did consider that, and we said that there was no basis whatsoever for distinguishing between operations, cyber operations, conducted by the military organs or other organs of state, or indeed organs of or indeed entities other than state organs that are attributable to a state pursuant to the law of state responsibility. No difference whatsoever. Now, of course, there are different consequences. If we have someone in the military, they enjoy what's called combatant immunity, belligerent immunity. It comes lots of different terms. But they enjoy immunity from prosecution for attacking valid legal targets, whereas a civilian would not enjoy that. So there are different consequences. But in terms of the legality of the operation, it doesn't matter if it's being conducted by someone in the military or an intelligence agency or whatever. I hasten to add, although we pretty uniformly agreed that was the law, virtually anyone who's worked with the government thought that there were few ideas stupider than outsourcing the conduct of military operations to civilian entities, including intelligence agencies. There was almost universal consensus from the ICRC representatives in their personal capacity, I add, to Mike Schmitt at a war college, that was an incredibly stupid idea for all sorts of reasons, but not for reasons of law. And as I said, we were slave to lex ferenda. Because you can't control these guys, because you saw the horrible, horrible use of private military companies in Afghanistan and Iraq. If you want to talk about people that are against private military companies, don't talk to NGO people. Go talk to a Marine colonel, okay? That guy hates them. The same is true in cyberspace. I'm much more comfortable with U.S. Cyber Command conducting operations during an armed conflict than some company that's been contracted to the Department of Defense. Hard to control them. Cowboys is the term we use, cowboys. So that's my last question, so thank you very much for your attention.